Highway Patrol. Hey, reason for the stop? We just noticed you have the out-of-state plates. Wondering what your business here in the state of Texas is. Specifically along this route and everything.
Yeah. Okay.
Can you roll down your window, please?
Oh no, that's fine right there.
Okay. All right.
Yeah.
What's your business here?
What does that have to do with the what did you stop me for?
So it's a reasonable suspicion stop, right, based on this common smuggling route.
Okay.
And out-of-state plates.
Yeah, but what's the crime though?
I'm sorry?
What's the crime?
So there's not been a crime.
Okay,
right?
so then I'm free to go. Am I detained?
It's a reasonable suspicion stop.
Yeah, but you need to have a probable cause if you're going to detain me. Am I detained or am I free to go?
You're free to go.
Okay, thank you, sir.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer and instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, advanced criminal investigations, etc. And today we've got another video from Texas DPS, Texas Highway Patrol. And in this video, I don't know, man. I don't know. I really don't know what the trooper was getting at, to be 100% honest with you. So we're just going to break down the case law in totality, okay? So let me just be very honest with you. Again, I cannot say what they're thinking. I don't know why they didn't think that they were conducting a traffic stop or the guy was detained, but let's just talk about it, okay? So let's look at our first case law. So what is a traffic stop? So a traffic stop is when you stop a vehicle because you have the minimum of what's called reasonable articulable suspicion. So when the trooper said this is a reasonable suspicion stop, what you're saying is it's a traffic stop pursuant to in accordance with the United States v. Cortez 1981 and all the aforementioned case law that's there, right? So in order to stop somebody, you need, whether it's in a car or somebody's walking down the street, you need what's called reasonable articulable suspicion. So a reasonable articulable suspicion stop when you're in a motor vehicle, it's called a traffic stop. I know, wild. It's wild and crazy thought. Now, the next thing we have to understand is if you're on a traffic stop, are you being detained? Well, pursuant to in accordance with Brennan v. California, you absolutely are. So for this trooper to say, hey, we're conducting a reasonable suspicion stop, we're conducting a traffic stop, but yet you're not detained, it's just wild. I have no idea. I have no idea what he was thinking. I have no idea what he was getting at. Now, the only thing I could possibly imagine that he was trying to infer, maybe he read this case law right here somewhere in the archives and he just didn't understand it. But United States versus Arvizu 2002 is a case where officers' suspicions were aroused by location of vehicle in the desert in rural Arizona. The vehicle slowed when it approached the officer. Children in the minivan waved at the officer in a manner that struck the officer as unusual, and the driver did not acknowledge the officer's presence. The Ninth Circuit had previously held that these factors could not even be considered by a court in determining whether there was a basis for stopping the vehicle. The Supreme Court unanimously held that under the totality of circumstances test, all facts may be considered by the court in reviewing the officer's basis for stopping a vehicle. The court noted the officer was entitled to make an assessment of the situation in light of his specialized training and familiarity with the customs of the area's inhabitants. And so, obviously, in that traffic stop, they found drugs, and everybody was, the drivers and everybody were arrested. And then the Ninth Circuit tried to suppress it, but ultimately, the Supreme Court said no. An officer may conduct a traffic stop based upon reasonable articulable suspicion. And again, that's just reconfirmed in United States v. Cortez 1981. So, again, I have no idea what these troopers are talking about. I have no idea what they're trying to get at. But what blows my mind is if you're going to conduct a traffic stop, just do the traffic stop, right? Because if you are saying, oh, well, no, I have no reasonable articulable suspicion of a crime, then guess what? You had no lawful basis to stop somebody. So either you have it or you don't. You either are stopping somebody constitutionally or you're not. So according to these troopers, by their own admission, they illegally stopped this gentleman. And again, maybe they did. I don't know the events leading up. I don't know what all their elements are, but yeah, completely just ridiculous sentiment altogether. Again, Texas DPS, a little more case law, please. So there you have it. And then just to kind of sum everything up, the gentleman said you need probable cause in order to stop somebody. Again, it's not true. We went over the case law. You just need what's called to conduct a traffic stop or to detain somebody. You just need, again, what's called reasonable articulable suspicion. And that's for in a vehicle that's pursuant to in accordance with United States versus Arvizu 2002, and then also affirmed in United States versus Cortez 1981. Well, I hope this video was helpful for you guys. If you have any questions, leave in the comment section below. Tell me what you think about this. I want to hear from you in the comment section. As always, guys, long live the Republic.